Hello, and thank you very much for joining this LexisNexis webinar. My name is Matthew Leopold, and I look after brand and insight at LexisNexis. And today I'm going to be chairing the panel for this webinar that's going to look at efficiency versus output and exactly what's happening with the embrace of generative AI. Please feel free to ask some questions. There's a panel on the right-hand side of your screen, and I will do my very best to put some relevant questions to our panel as we go through. The webinar is being recorded for posterity, and you will all get an email with a recording of it later on if something is said that you want to catch back up on later on. And today we're going to be unpacking the insight that arose from the latest LexisNexis thought leadership report on fast law and why speed is a priority for lawyers using AI. But before I delve into that, let's just meet our panel. We have three leaders in the law and AI joining us today, each with a slightly different angle. I have Laura Hodgson, who's the generative AI lead at Linklaters. She started on the tools as a regulatory insurance lawyer and then led the knowledge function for a global law firm. Latterly, she's taken on responsibility for generative AI exploration and implementation at Magic Circle firm Linklaters. She's now responsible for creating and delivering an AI adoption strategy, no small task for a firm the size of Links. Next, there are titans in the world of the law, and then there's John Quinn. And he probably needs no introduction. He's often referred to as fearless in litigation, and certainly in that respect, his reputation precedes him. He is the founding partner of Quinn Emanuel, the largest and apparently most feared law firm in the world that is solely dedicated and devoted to litigation and arbitration. So please be kind to me, John. He has very strong views on where AI might take law firms and litigation in the future, and I'm sure we'll hear much more about that in due course. And then finally, we have Tom Whitaker, a senior disputes and litigation lawyer at Burgess Salmon, who are ranked as a global market leader in AI law by Chambers and Partners. Tom specializes in high-profile, complex and data-rich litigation, investigations and inquiries. He also leads Burgess Salmon's AI regulation team, advising and training clients on AI regulation and risk. He trained and qualified at Alan Novery, which included advising DeepMind on its acquisition by Google, which sounds absolutely fascinating. But anyhow, thank you very much to our panel for joining us and to the task in hand. So over the last 18 months, Lexis have been running a number of really large surveys across the legal market, trying to uncover changing perspectives and views on generative AI. And our latest report is definitely well worth a read. But there are three big trends that I want to discuss with our panel. Firstly, we'll look at the actual real-life impact of AI on human lawyers. Secondly, looking at the implementation of generative AI into law firms. And then finally, looking at AI's impact on clients and the trust aspect of the law. So adopting AI technology is clearly becoming a when rather than an if. And looking at the impacts of those is really important. And our report told us that 71% believed that generative AI would help them to work faster. To my complete surprise, only 33%, a third of our survey, said that they felt that it would allow them to bill more hours. And an enormous 53% said that they thought it would give them a competitive advantage. So let's have a look and see what our panel think. So maybe, Laura, let's start with you. Many firms are still figuring out what AI really means for their practice. What do you think are the most notable changes that AI has brought to day-to-day legal work?
Well, I think if I'm going to be accurate about that, I don't think it has yet brought changes to legal work. What it has changed is people's attitude towards the opportunities available, the opportunities to change how they practice. I think if we're honest, we are not yet at a point where this technology is actually changing an awful lot of what we do day to day. So perhaps somebody's going to challenge me and say, no, we're doing this end to end, but at the moment we're exploring in particular areas, we're looking how it could impact us, and we're looking at the opportunities. And I think that's where the most exciting conversations are, which is what can we do with this technology, not what are we doing with it.
You're nodding along there, Tom. You agree?
On the whole, yes. I think some forms of AI have been used for a decade plus, for example, in e-disclosure. But putting that to one side, where that's for a specific purpose, usually with a third-party vendor and with specific tech, the difference now is that you have Gen AI, which can be used by more people at enterprise level for more tasks, and it's easier to engage with as well. And I think it's fair to say that from what I've seen across the market is that people are really excited about the opportunities, but there are very few specific, concrete, tangible examples that people are talking about. I've started to see a few of them come through, but we're still at the early stages of that. So I think this is very much evolution rather than revolution, and we will start to see those concrete examples more next year.
Interesting. John, what about you in your litigation world? Has AI started making a difference yet, or are you still looking in the midterm?
No, I agree completely with what Laura and Tom have said. It's very much early stages in an evolution. It's certainly, we're nowhere near any type of paradigm shift or major change in how we do work. I mean, we're able to generate documents which can be kind of sometimes a first draft. That's not something you'd serve on the other side or file with the court, but sometimes a first draft, something that you can start to work with to prepare a document. It's useful as a check. You know, maybe there's some authorities you haven't thought of. It's a useful check on that, the work that you would do anyway. It's very useful for querying large volumes of data, document production. We call it, discovery in the US. In the UK, you call it disclosure. You get huge volumes. You can query that and get some feedback, get some answers. I wouldn't rely exclusively on any of the output of AI, I would say, up to this point. Yes, it's useful, it's valuable. I'm no doubt these large language models are going to get better and better, and they're going to become more and more important to our practice. But at this point, it's kind of an incremental change.
Interesting. So what in your view, John, is the next big step, right? Are we close? Is it technology's not there, or are we just still blinkered to our own world and our own processes and not yet ready to embrace the opportunities that it brings?
No, I think the technology has a ways to go, actually. I think there are a lot of people, we have people in our firm with technical backgrounds, who were data scientists or engineers or computer scientists before they became lawyers, and they have an understanding of the technology, eager to use it, but I just don't think it's that good yet that it can really replace the human, human laborious task of creating documents that you can actually use in litigation. Again, I think of it as a check, as a background check on what we do. I think it is very exciting to be able to query large volumes of data. You can imagine a circumstance where, let's say there's a litigation over what's the capacity of some type of plant or facility. And you have a lot of documents and data relating to the project, and to ask it, what was the production capacity or what was the output as of a certain date. It's kind of amazing that you can get answers to that. It's a starting point, but I wouldn't rely on that answer necessarily.
Interesting. So Tom, right? John has explained there, right? Actually, the efficiency side of things and the ability to check are the big issues for him. Well, where do you sit? What do you think the changes that might make an impact to you and your work?
So looking at it from, say, the disclosure perspective, some of the bigger risks, some of the bigger challenges, and where the costs and time have really incurred are around that large-scale document review, or where you need to build out other documents such as chronologies, or whether you need to do some deep analysis over multiple documents. And so those are examples where Gen AI could really be useful as part of a much wider workflow of trying to understand what your objectives are, what your parameters are, and how it is you're going to build out those workflows. So where you start to understand where AI can be used for specific tasks, such as interrogating the data in a different way, reformatting the data in a different way, identifying conceptually or semantically similar phrases or those sorts of things, then you can better use it as part of a much wider workflow. So where I'm thinking in the medium term is that after a year or two where there's been great enthusiasm by so many people and you're bringing together all these different ideas and perspectives, you're identifying the use cases and the problems, and you're working out how you build it into your workflow, we're starting to see those promising use cases where we've thought through some of the risks, we've thought through the issues, we have an understanding of the nuances and how we can properly use it within the workflow, and then it'll be more likely next year where we can really start to deploy it more. The example that we've had is where we've been using it to build out chronologies. We've learned a lot from that as to, well, what is accuracy? And what is it that makes a really good output? And where are the trade-offs between the speed of all of this and the accuracy and the cost, and the time saving, the opportunity cost, versus the traditional approaches that we would have had? And how do we want to approach those different options and discuss them with clients? And that's what I'm hoping we'll be able to do even more of next year.
Yeah, I mean, if I could mention one really kind of novel use that we've already started to make is during the examination of a witness, whether at trial or at deposition, if the witness says something, you can do an instant check on what has the witness said on this subject before. Has the witness ever said something contrary to what the witness just said? Did this witness have, or do we have any evidence that this witness has spoken to this other witness on this subject before? So you get a reaction in real time, which is extremely valuable. In preparing for an examination of a witness, you won't be able to anticipate all the witness's testimony. So it's very hard to have that kind of capability and preparation in advance. This gives us a new tool, a capability that we didn't have before. And I would say that that's new and extremely valuable.
Absolutely. And so let's take Linklaters, Laura. So on the scale of efficiency to the quality of output, with, as John just suggested there, the ability to bring that extra voice, that extra mind to review data and come up with different angles. Well, where does a big organization like Linklaters sit on that particular risk matrix?
Apologies, my internet is dropping in and out, so I actually missed a lot of that previous conversation. But why don't you repeat it with a bit of the background that I might have missed, and then I can give you a better answer.
Well, let's. What I'm really interested in is, so Linklaters as a massive organization, you're going to have a scale of risk, and we've heard from John about how AI can really drive efficiencies, but it can also improve the quality. It can spot errors, but it can also create a voice that can help pick holes and identify different angles on arguments and summarize cases. Now, clearly, that's an enormous efficiency benefit, but there is a quality risk, right? And in fact, someone's just asked a question about the risk of bias and incorrect answers and hallucinations. How does a big giant like Lynx deal with that spectrum of risk?
Well, we are taking, as you might expect, quite a conservative approach to this, and we are working back from kind of first principles of client confidentiality, data privacy, all those things, regulatory obligations, and then stepping back to say, with those in mind, with those as a given, how do we operate around that? How do we make sure that AI is really adding value to the work that our clients are being given? And there are so many things that AI really can add value to, in terms of making sure that people have a bit more time to do that thinking that, frankly, they're paying a firm like Linklaters to do, which is not just processing documents or administrative tasks, but actually applying the brain work, the commercial acumen, the instinct that we want all of our lawyers to share with our clients. So we're trying to get that balance right between which needs a little bit of thinking about things like training and skills, making sure that the technology is there as a tool to get the best out of our lawyers in terms of providing excellent advice. And that's the continuum. We're not, we're helping people to use the technology and understand what it can give, while also making sure they're very aware that actually the unique thing that they've got is their experience and what they've seen in the market, and practical problem solving, which can't be replaced by AI, at least not now.
So this is really interesting, I'm intrigued. So it's that thinking time with AI's ability to take on some of these tasks, just as John explained. How do we ensure that legal professionals continue to grow their skill set when you can just depend on AI to do so much of it? How do we maintain that really important critical thinking? When essentially a computer bot is going to start to cover some of that ground. I don't know, Tom, do you want to come in first, and maybe we'll go to you, John?
The starting point is understanding what AI can do, and consequently what it can't do, and consequently what humans are in the right place to do. It's also about understanding that AI is not the be-all and end-all. It's not the magic bullet. It's part of a much longer workflow for you to go from your client's issue or problem and then to ultimately whatever the outcome will be. So, for example, you need to get the data right. You need the right data from the right places, labeled in the right way. You need to understand how it's managed. You also need to be thinking through your prompts, and you also need to be thinking about what your objective is. So in what format, what output it needs to be, who's it going to be for, who's the audience, what are the objectives, and so on. And I think with a lot of this, then you can just go back to those foundations that we're trained on and that we should be applying every day, which is, what does my client actually want? What are their objectives? What's the law? What's the procedure? What are our regulations? Those sorts of things. What's the objective? And what do the audience need from this? Who needs to engage with it? And all of that will affect all of those stages along the way, including how you use the AI as well.
Thank you. And so, John, what about litigation? The most human of you have to stand up and build an argument. So is there a risk of over-reliance on AI in your section of the world?
Well, we're nowhere near that. We're nowhere near that. Although I understand in China, they are what we would call in the US small claims courts, where parties can appear by avatars and submit their cases to an AI for decision by consent. They agree to it, and it's a binding decision. That's an interesting concept. I suppose if that were, that raises the potential that if it were that good and it could address larger claims, maybe you wouldn't need human advocates. But we're nowhere near that. We've had electronic calculators and computers for decades now, but people still learn math. We still need to learn how to add up figures ourselves. I do think there is a larger potential issue down the road, but it's not just for the legal profession. It's for the human race. And that is the potential infantilization of human beings if AI permeates our lives and is making decisions for us. Now, we're nowhere near this now, but we can all imagine a scenario where we become reliant on AI to tutor our children, to take care of our homes, the settings, lock things, the temperatures, drive our cars, everything we do. At some point, you have to ask yourself, is there a potential to become over-reliant? And what impact might that have on the way humans think and deal with each other? I think that's a larger issue. We're probably decades away from that.
So do you think that actually AI is it's another table stakes thing? It's a core. And the idea that 50% odd people were saying it's going to give them a competitive edge, are you suggesting that you think actually it's quite a long way away before that competitive edge is going to manifest itself?
Look,
truly?
we're trying to understand AI and what tools are available out there. The law-oriented AI applications, we review them. We have a committee that reviews them. I'm sure Tom's firm and Laura's firm does the exact same thing. We're not going to have a competitive advantage over each other. We're all trying to learn what's available in the marketplace and make good decisions. So it'll raise the game for everybody, I think.
Any thoughts on that, Laura, on the competitive aspect?
Yeah, look, I completely agree. I think it's worth thinking across the market. There will be some parts of the legal market where actually cutting out some of the really slow admin that can happen with certain business models, AI might effectively give you some kind of competitive advantage. There are other parts of the market where it really won't impact what's happening at all. And I think, if we're honest, a good lawyer is a good lawyer. Somebody who will listen to their client, provide great advice. Sometimes that's got nothing to do with actually talking about the law per se. It's based on experience and insights and what you've seen elsewhere. That's a great lawyer. It's not just somebody who can churn out black letter law when required. So I think, look, this is not going to challenge the market for a while. I think there'll be parts of the market that will probably see change more quickly than other parts of the market. But I think that's right. Look, it's just too early to call that. But let's see in 18 months' time.
Yeah, quite. Well, so from a regulation point of view, Tom, is regulation going to enable this change, or is it going to slow it down? What's your view on that?
So across AI more generally, plenty of people are calling for AI regulation because there's a feeling that something needs to be done, both to address the opportunities, but also the risks. And so you see, say, in the EU with the AI Act, many people are very happy that that's being progressed and that's addressing some of the fundamental risks that the EU has long been concerned with. But you equally see plenty of people who are saying more prescription around those things, more regulation, more red tape. Actually, it is detrimental to innovation and it doesn't necessarily address all of the risks. And the UK is going through similar issues as well. To bring it to a litigation context, you see similar things have played out within disclosure before, where the rules have been changed because there was a concern it was taking too long, it was too costly. And then you had PD 57 AD for the business and property courts being brought in. Where I think this then takes us is that there will be a concern for the use of Gen AI within law firms and litigation of, well, how do you try and encourage responsible, appropriate use of it? Do you need to have additional guidelines, additional procedural rules, or actually do we have enough at the moment? And I think it's clear from the CPR, we've got the overriding objective, which sets us with a really good foundation to be efficient and to support the court's work and to put the parties in a good place to be able to further what the court is doing. And then the CPR, with disclosure, doesn't necessarily prohibit and indeed encourages technology in some ways. But the parties still need to find a way of cooperating and working through to see if Gen AI or indeed another form of AI is appropriate for their matter as well. So you can take a lot of parallels from the world of regulation of seeing some of the issues that are coming through, which are also relevant here too.
Thank you. So it looks like we've just lost Laura again. So if you don't mind, John, from a US perspective, and I guess you look after a law firm, so you're going to see a global perspective. What's your view on that regulation? Is it the enabler? Is it a blocker? What are the opportunities or the changes that need to come?
Look, in the US, so there have been some unfortunate incidents of lawyers who have filed documents with the court citing cases that don't exist, authorities that don't exist. As you can imagine, the courts weren't very happy with that. And some judges around the US have adopted their own standing orders in their courtroom regulating the use of AI and basically saying, some say, if you've used AI, you need to tell me. If you've used AI, understand you are ethically responsible still. You can't blame the AI. I think all that is unnecessary. Of course, the lawyer is ultimately responsible for what is submitted to the court, whether an AI is involved or not. So from a regulation standpoint, as it relates to litigation, I don't think regulation is good. I mean, lawyers have ethical duties. They're responsible. They have duties to the court, and you have duties to your client. You're not going to be well serving your client if you are citing AI fabricated authorities. So I don't see regulation having much of an impact, at least for the legal profession. There's a lot of regulation going on in the US of AI, not out of Washington, D.C. We can't seem to get anything done in Washington. We have no privacy law at the federal level in the United States. You heard me right.
Really?
There is no national no bills can get out of the committee that's been mooted about, but for years now, basically by default, GDPR reigns. This is a phenomenon, what's sometimes called the Brussels effect. By default, the European rule becomes potentially in privacy, a global rule. The European AI Act may do the same thing. About half the 50 states have some form of AI regulation. The focus a lot is on, biased decision making in employment, in housing, in loan applications, the like. There are rules like New York City has an ordinance that says if you're going to use an AI tool in making an employment decision, you have to have your data set audited and certified that it's an unbiased data set. Well, what does that mean? If you talk to a data scientist, they'll tell you that's a very difficult thing to do. You have to define terms. If you try to make it unbiased one way, it's probably going to be biased in another way. So we're definitely going to need the help of data scientists and AI experts in designing regulation. But that's one area which is, that type of concern about bias in decision making has been picked up in a lot of the state legislatures in the U.S. Another area that gets a lot of attention, as you can imagine, is deep fakes and the identification of authentic versus inauthentic material, and some of the, and also facial recognition. And so some of the states have enacted laws relating to that. California, there was just an effort in California to, adopt a comprehensive AI regulation, which, unlike the European AI Act, which is really based on effort to kind of identify and address uses of AI by level of perceived risk. In the California bill, it was really based on what's the size of the data set, how large is the large language model, and if it was beyond a certain level, it was subject to certain filing requirements and some regulations. It passed the state assembly. Governor Newsom vetoed it. So we're back to square one, in California. There was so much industry. It was really interesting to see how that played out because, as I recall, I think Anthropic, Musk was in favor of it. Anthropic, I think, was in favor of it. OpenAI was against it. There was a real division in the AI industry about this proposed law. It's all history now because, it was turned out to be much ado about nothing because the governor vetoed it. But it was a real hot potato. And I think we're gonna see that continue. There's gonna be real struggle to get a consensus on what regulation can look like. I think the whole world is probably going to have to comply with the European AI Act.
Yeah, interesting. So, Laura, thanks for coming back in again. John, in summary, made a quite an interesting point about how the accountability for a lawyer's work rests with the lawyer. And there is an interesting question that's being posted in the chat about, does a lawyer need to understand the algorithm? Is that going to be something that's really important?
I hope not.
Yeah, no. And apologies for my terrible internet connection. But no, I don't think, a few years ago, there was this big push to say that all lawyers needed to learn how to code. And look, here we are now. Nobody's talking about learning how to code. It's the algorithm is not going to make a difference to the skills of the lawyer. I think what you can do is train your lawyers to understand what large language models are, how they work, basically what's happening, which helps people to understand that this is a tool. It's not a mythical thing that is some kind of, semi-humanoid. This is a tool that you can use to help you get better results in your job. To be great at your job increasingly means being able to use the best tools, to help you make an argument, to help you understand the fact pattern, correlations, that kind of thing. And I think the way to approach this is to make sure people are confident with using AI, understand its limitations, but we don't need people to understand the algorithms. That's my viewpoint.
Thank you.
I think everyone's relieved to hear that. Yes. Well, let's. Oh, sorry. Go on.
Oh, may I just briefly come on that? If it helps reassurance, then I totally agree with that. What I think is more important is not necessarily knowing all the answers, but knowing the right questions. And I think lawyers are in a very good position to understand that based on our understanding of the law, understanding of the procedural requirements, and understanding our clients' objectives and how we take a piece of litigation or whatever piece of work it is forwards. I think there's a real risk that if we start straying into trying to understand the answers, we're actually straying into highly technical areas, which are other people's domains. Basically which we're not equipped to deal with, and which is against our regulatory and client obligations as well. What's really exciting with all of this is that it's going to be a multidisciplinary discussion, both internally, like John was saying, with data scientists that firms have, but also externally with specialist vendors and the clients. And the key to all of that will be able to be about communicating effectively with all those different voices around the same table.
Well, and I think that brings us very neatly on to my next topic, which is about clients and client perceptions of trust. So, yeah, how do individual lawyers ensure that their use of AI doesn't undermine that client trust? What do they need to think about? What do they need to do? What's on your mind? Let's start with you, John, as I'm fairly sure this is one that you talk about regularly.
Well, I mean, clients don't want their data and their confidential information just typed into OpenAI to some system that's some model that's not a closed model. That's for sure. And we get that clients telling us that. All clients expect that. You know, well, rather than a question of trust, what we hear is some clients want to know. They want to make sure that we're making use, that we're exploring AI tools and making use of them. They want to hear what our plan is, what licenses we've taken, what apps we have access to, why we've chosen those. They want some confidence that we're on top of this and aware of it. I other than the issue about protecting their confidential information, that we don't hear much else from clients on use of AI. I don't think.
Interesting. So I wonder, Tom, same sort of question to you. What's your view? What's your firm's view on terms of how comfortable your clients are with their data being used in secured or insecured generative AI model, and how important is giving them the faith that you know what you're doing?
Well, on the topic of trust more generally, the way that I would put it is that, well, each client will be slightly different, but it's a case of the lawyer understanding what is the client's concerns, what's their drivers, so that they believe and they know and they have demonstrated to them that we stand with them and we share the same concerns that they have. And so for many of our clients, especially in the public sector, where there's additional security obligations, security clearances, information security requirements, etc., those requirements, the policies, the training, the values, the general culture and approach, all of those bits, we share the importance of all of those as well. And then that gets reflected through to our AI policies, our AI training, and the systems that we have set up as well to make sure that they are equally compliant when it comes to information security, and that our colleagues know what it is that they can do and can't do. But we've also found that through adoption, people genuinely want to adopt, and clients want to see how we're thinking about it and how we're adopting it. So it's been important to us to offer those safe and appropriate routes so that people can experiment in a responsible and safe way, and they're not inclined to go off to other AI tools and which may not be as responsible or appropriate.
And Laura, transparency clearly is an important part there, and revealing what you're doing and how you're doing it. But there's an interesting question just being posted as well about, does AI not breach the rules of confidentiality? So where do you sit on that view of confidentiality?
Oh, that's a really good one. And I think many of us probably immediately started to tell our people, please, that whatever you do, don't use go out onto the open market. Don't start putting client documents on ChatGPT. Brought that into our own environment where we know the security features are there, that client data is being protected. And our first response was about client confidentiality. So, and everything we do is based based around that. It is a technology where there are some particular risks related to confidential documents or data being transferred across in ways that we're not used to. I think if we apply common sense and we put the usual barriers around what people are doing, I think the other critical thing, which both Tom and John have talked about, is talk to your clients about what you're doing and get their permission to say, this is what we're planning to do. This is our approach. Are you comfortable with it? Yes. We have some clients who don't want us to use any of our AI tools on their data, and that's absolutely fine. It's an open conversation. But there are risks, and you've got to put those at the very front of the issues that you're dealing with when you start to use this technology with any kind of client matter.
Matthew, I'm going to have to sign off.
No worries. Thank you very much for joining us, John. We appreciate it.
Thank you. Bye-bye.
Thank you. Bye-bye. So I think that's interesting, Tom. So in your view, if a client comes to you and says, don't use AI, should firms actually respect that, but then try and hold their hand through the journey and get them so that they are comfortable with the firm using AI and using those tools? Or actually, is it as simple as black and white? If they say no, you shouldn't touch it.
The short answer is if they say no, then we shouldn't be using it. The slightly more nuanced answer is that ultimately we owe an obligation to our clients to advise in their best interests. In those circumstances, I would want to go through the options with them to say, you've got the Gen AI approach, cost, speed, efficiency, accuracy, opportunity cost, those sorts of factors. But then you have the other ones as well. Now, if you don't want to go down that first route, that's your choice. But there could be consequences as a result of that. So, for example, in litigation, if you then have to explain it to the court and to the other party, you may have to explain, well, why would you not be using one particular approach, which may have certain benefits in certain areas? So as long as the client understands that, that's all, and the lawyer is advising on that, ultimately it's for the clients to decide.
You agree, Laura?
Yeah, and that conversation has actually shifted a lot just in the past 8 or 9 months. So when we first started on this sort of journey, a lot of clients were understandably cautious because they didn't understand what law firms were doing necessarily. I think the more you open up and you're very transparent and you basically, take clients along with you and bring them into conversations about what you're doing, then that dynamic changes. And I think it's similar to any other innovation in law, that there is an understandable what you're doing with our matters, and then depending on how you approach it, that eases, and you tend to find people are now saying, actually, can you help us? We want to get to where you've got to. Maybe that's a way we can work together, and that's a really, really nice place to be.
Indeed. So let me leave you with a final question to the both of you. As ever in life, we look at, can we do things faster? Can we do it cheaper? And can we do it better? And it's a model where usually the argument is you can do 2 of them, you can't do all 3 of them. Does AI mean that we can do it faster, we can do it cheaper, and we can do it better? And what are the potential impacts of that on your training, your teams, your approach to charging and billable hours, and on all those other factors? I appreciate it's a very, very meaty question, but this is really, I think this is the future. This is where we're starting to go. So I'm really interested to see what your views on that might be. Tom, why don't you kick us off?
Well, that is a broad question. So the segue there is maybe AI is ultimately a broad suite of technologies, and then it is integrated into different types of platform, and then you have different workflows, and so that it can be used for so many different tasks. So when we're talking about doing things faster, cheaper, and better, that will look different depending on the task. If the task is about drafting a shorter update to the client or doing a cost report, that's very different to review of 100,000 documents as part of disclosure compared to trial preparation or something like that. So I think we will start to see those use cases where you can see actually certain things can just be done faster, at lower cost, and still achieve the accuracy and the quality we want in the way that we want, so that we can then use it however it is we would normally use it. There will be other things which are at a much longer term evolution in respect of all of that. There's a difficult bit at the moment, which is that expectation setting, because you have plenty of people who see a lot of the marketing out there and go, oh, we can achieve everything immediately with everything. And actually, when they start to play with it, they go, actually, the work that they're doing is quite complex, and specifically what they're after is quite difficult. And so identifying those use cases which have the short-term impact is very different to finding those ones with the long-term impact. And then when it comes to the training for those ones as well, what I think I've really seen in the short term is that by trying to work out what it is that you want to achieve, your purpose, and then how you can get the AI tool to make use of it, it's actually made me reflect on how I go about working with colleagues, other humans, working with clients, and actually what it is that I'm asking people to do. So when I'm giving an instruction to go and draft a particular thing, use this data, go and extract this data and format it in a particular way for this purpose, for this audience, because I've been having to really think about that even more explicitly for use of AI tools, I'm hoping that's also translating to how I'm working with colleagues, and that I'm setting that purpose and I'm discussing those approaches much better as a result. So I think from a training perspective, if we stick to those sort of foundational aspects to it, that will really help us find those really good short-term use cases and work out how we can achieve those really good long-term, more difficult, higher risk, higher reward, long-term use cases too.
That's a really, really good point. Thank you. So, Laura, what about you? And you know, we're affirm the size of links. You know, there is the pressure between these faster outputs and the need to maintain high quality legal work and charge for it. How do you foresee that happening from your point of view, in the implementation, particularly of AI, and the training you need to do for the staff to utilize these tools?
It's a really interesting question, and you could set out to say everything we do is designed to just increase the speed at which we do things. We will set certain standards for what we want that to look like, and we'll reduce our costs, and everything's going to be pretty much automated, and we can price around that automation. And that obviously is an option. You can go for that. It doesn't really fit with the type of work that we do at Linklaters. So inevitably, because when matters are particularly complex, I think you're never sat with a task where you can press a button and you get results spat out the end. The machinations that you have to go through, the different colleagues and departments, and bringing people in at different stages when you discover new fact patterns, means that everything always ends up being a little bit more complex than anyone anticipated at the beginning. So exactly as Tom said, it's using this technology to understand where you need to bring in the people skills, I think. So it's a slightly different impact, is that, yes, you may be able to do things faster. You hopefully, if you use it in the right way, will be able to get better quality results. But the reason you're getting better quality results and that the work is faster is because you're reducing some of the administrative tasks, which at the moment law firms actually don't even recover. It's pure admin and some of it remarkably old-fashioned tasks that are being done that should have been automated a very long time ago. And what I'm very focused on is increasing actually the human skills. As I mentioned a bit earlier, they're going to talk to your client, listening to their problem, finding diverse opinions on how to resolve that problem, and that is going to inevitably mean that we're doing that extra time thinking in a creative way and doing more problem solving. I think, look, for everyone's benefit, it would be better if law firms were a little bit sharper at what they did and did things in a perhaps give clients a better experience on the other end. But it's not necessarily about the it can't compromise the quality of the advice. But I think we could all work harder and use AI to be our friend, to just be slightly better at some of the more tedious things.
Super. Well, what a perfect place to wrap this up, just in time for everyone to go and get a quick bite of lunch before life resumes. So thank you very much. A huge thanks to John Quinn, who obviously has disappeared, and to Tom and to Laura for your time, your expertise, and for answering the deluge of questions that we have been sent in. So thank you very much to all of you for joining us, and we'll catch you at the next one. Thank you very much, everyone.